the notice of appointment filed by ISA and company advocates is struck out. The 4 commissioners are at liberty to deploy and utilize the services of Senior Counsel Paul Muite and Isa Mansour advocate if they deem it necessary in these proceedings. Direction number 3, pleadings filed out of time. As regards pleadings that were filed out of time for whatever reason, whether because the judiciary electronic filing system was down and or slow, or due to late service, we direct as follows. On account of the dictates of Article 48 of the Constitution of Kenya 2010, in respect of access to justice, national importance nature of the presidential election petition, we direct that all pleadings that were filed out of time, including those that were filed by 2 p.m. today, be and are hereby deemed to have been filed in time. The parties against whom such filings are made shall not respond to them by way of replies, but rather shall be at liberty to respond to hearing. At all times, this court reserves the right during judgment, upon consideration of the issues therein raised and the relevant law, to expunge from the record pleadings that offend the procedures of the court or have the effect of mutating the original petitions. Number 4, scrutiny. We direct the Inspector General of Police, in liaison with the Registrar of this court, to provide adequate security during the exercise of scrutiny. Direction number 5, additional counsel. Excuse me. The number of counsel permitted in the courtroom beginning tomorrow remains as directed by this court this morning and shall be firmly enforced. Direction number 6, further affidavit. Learned counsel for the first respondent, the Honorable William Samuel Ruto, has informally applied for leave to respond to 2 affidavits presented by the Attorney General in petition number E007 of 2022. With effect from today, the 30th day of August 2022, 2 p.m., as indicated in paragraph 3 above, the court will not entertain any further lodgement of pleadings. However, counsel is granted leave to respond to the 2 affidavits that were presented by way of oral submissions at the hearing. Direction number 7, amici applications to participate in scrutiny. Mr. Charles Kanjama, Senior Counsel, Counsel for the amicus John Walubengo, Counsel for the amici John Walubengo, Dr. John Sevilla and Martin Mirero, has made an application to participate in the scrutiny exercise ordered by this court in a ruling delivered today, the 30th of August 2022. He now wishes to make a report on the same and, if need be, amend his amicus brief, which is already on record. Quite rightly, apologies, we will omit that bit. This is the direction. The role of the MEC ought to the written brief, that's common knowledge. Indeed, when we admitted Mr. Kanjama's client in this matter, we specifically stated that the MEC will not make oral submissions and shall rely solely on their written brief. In addition, we reiterate the guiding principles in the case of Francis Murwatetu and another versus the Republic and 5 others. Supreme Court petition numbers 15 and 16 of 2015 consolidated, 2016 EKLR, and an amicus curiae shall not participate in interlocutory applications unless called upon by the court to address specific issues. Consequently, we decline this particular request. Those are the further directions of the court, and they are signed by the 7 of us. Thank you, Judge President.
Thank you, Vice President of the Court. Those are the directions. We have a long journey ahead of us. We have to prepare for tomorrow. But for the sake of the advocate, Mr. Omondi, who rose on his feet to speak about his client, Professor Wanjakoya, just to remind him that we do not have a petition under Article 140 challenging the election of the president-elect. We also do not have an application seeking to join the proceedings. You have heard the directions given that we have closed the proceedings. In any event, we have also made an elaborate ruling where a similar candidate, the Honorable Mwaure, was seeking to join the case as an interested party, and that application was declined because we do not allow interested parties under our rules. Therefore, the lawyer, the advocate, unfortunately, you can't make an oral application at this late stage. Proceedings are closed, and we have to deal with the parties that we joined this morning in the consolidated appeal. With that, Learned Counsel.
Please, with your very, very kind permission, bring one issue to the attention of the court. We are working very hard to comply with your order for scrutiny. We know that in 2017, the court was not happy with the pace at which the commission worked. But 2 little issues remain for clarification so that we may expedite. Can my learned junior please do that?
Scrutiny is an ongoing exercise from this afternoon up to Thursday, so that is okay, Counsel.
Thank you very much, my lady, the President of the Court, the members of the Court. We had occasion this afternoon after the Court broke to compare notes with the Registrar in terms of how the orders on scrutiny will be complied with. And a few issues arose, which we agreed that I will present before you for your further guidance. In relation to the second order that the Court gave, that is the order in relation to access to the servers, we would wish to get a clarification from the Court as to whether that order is to be taken to mean a read-only access. That is for the obvious reasons that might come with the order that goes beyond a read-only access. In relation to order number 5, the court did direct that we avail ballot boxes in relation to a number of polling stations. Now, reading through the polling stations that have been identified, some of them are actually polling centers as opposed to polling stations. So we wanted to get a clarification as to whether where you indicate a name that refers to a polling center, then it, as of necessity, also means that we are talking about ballot boxes from the center and not from the polling station. In relation to order number 7, that is touching on the Form 32As, these forms, my lady and my lord, is supposed to be kept in the ballot boxes after close of polling in the respective stations. It then follows that if we are to avail them, then we may need a further order that we can open those boxes and avail the specific Form 32As. We wanted that clarification. Finally, as part of compliance with the very strict timelines that the court has given in relation to the scrutiny, we did write to the registrar of the court so that following that order number 7, the part that says that the IBC should provide certified copies of Form 32A and 34C Book 2 used in the impugned elections, subject
that are turning out to be polling centers. I think that has been a common mistake as to when it's a polling station, a polling center. Our position should be that if it has been described as a polling center, then the order would relate to all the polling stations in that center. And lastly, in respect of the access, this court has said that we are to have supervised access. And then the question would not be whether it will be described that read only. We are to obtain all the necessary access to do an audit of the information that is needed, so long as it is supervised. That is all.
Thank you. I will request the Honorable Mr. Justice Lenaura to respond to those issues on behalf of the court.
Thank you very much, Judge President. Let me begin from the last issue, Mr. Mwangi. Indeed, it is polling stations. Following Maina Kiai, anything to be done must begin from the polling station. So where there's a reference to Belgut polling center, it refers to the polling station. So again, that should be the reference that you're talking about. So let's follow that direction. On the question of contested polling stations, I think that's resolved. You will give the list to the registrar and to the applicants and to the IBC by close of business today. On prayer number 7, that is a typo. The reference is to forms 32As and 34As, not 34Cs. 34C is so it's 34A. And so we amend the direction to read that. On the server, Mr. Kilukumi, I think that I don't have the orders here, but the last order allowed 2 agents from every interested party to appear at the centers, whether it is at Forodha House or at IBC, and that resolves Mr. Katwa Kigen's question on venue. I think from the orders, you can only have 2 venues, one at IBC and one at Forodha House, where the